Mr Hodge.
Commissioner, the witness for the first case study is Mr Regan.
Mr Regan in the room. If you'd come into the witness box, please, Mr Regan. If you go back. Mr Regan, would you prefer to be sworn or to make an affirmation? Take an oath or an affirmation? Which?
Affirmation's fine.
Affirmation.
Thank you.
Thank you.
I solemnly and sincerely
I solemnly and sincerely
declare and affirm
that
the evidence I shall give
the evidence I shall give,
will be the truth,
the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Do sit down. Thank you, Mr Regan. Yes, Mr Crutchfield.
Commissioner pleases. Now, Mr Regan, do you have an original of your witness statement
We'd
with
better
you?
have name, rank and serial
Yes.
number and all the Geneva Convention details first, Mr
Do
Crutchfield.
that. We'll do that, sir. Do you have it there, Mr
Yes, I
Regan?
do.
Yes.
Well, can we
is
have
your
his
full-
name?
Is your full name...
Yes.
could you tell the Commissioner your full name, please?
Anthony George Regan
And your business address?
is 33 Alfred Street, Sydney.
And your current occupation?
Group Executive for Advice in New Zealand for AMP.
Now, do you have with you the summons that you were issued by the Royal Commission to give evidence today?
So I do.
Do you have an original of that document with you?
Yes.
That's the summons?
Yes, I do.
That's the summons you were given, is that right, Mr Regan?
Yes, it is.
Commissioner, I tend to the summons.
Exhibit 2.12, summons to Mr Regan.
And Mr Regan, you have your statement there, you've already said, I think.
Yes, I have.
Have you read your statement recently?
Yes.
I understand there's one matter that you want to update, and Commissioner, it's paragraph 335.
Yes.
Do you have that there, Mr Regan? If you go to paragraph 335 of your statement.
Yes. I have the paragraph.
Now, could you look, please, at paragraph 335B,
Yes.
and there's a statement in that paragraph, the charging of OSFs prior to certain customers going into the buyback pool, delete the brackets, or ignore the brackets for the moment, to date approximately, and you see that number there, 10,000,
685.
yes, is that number correct?
I believe it's been updated.
Yes, and what's your belief as to the updated number?
I don't believe I've been provided with
If
that.
you don't-
1,000 to 1,500.
About 1,000 to
I believe is the
1,500.
correct number.
And if you go over the page, you see the last sentence in that sub-paragraph. AMP estimates that approximately 1.06 million will be paid.
Mm-hmm.
Is that figure correct?
I believe that's been updated to 200 to 300,000.
All right. And look at paragraph C, please. You see the reference to the customers there, 3,108.
Yes,
Has that figure been updated?
not that I'm aware of.
And what about the monetary sum in the second last line, 1.2 million?
Not that I'm aware of.
Are there any other amendments that you wish to make to your statement?
No.
Are you otherwise satisfied the contents of your statement are true and correct, Mr Regan?
Yes.
Commissioner, I attend to the statement.
Exhibit 2.13, statement of Mr Regan.
And
just to
the
be
exhibits.
And its exhibits, just to be clear about this, Mr Crutchfield, do you propose to have the witness change what appears in 335B, or simply have his evidence amended in the fashion or amplified in the fashion you've indicated?
The latter, it's an
Yes.
update, yes.
Very well. Exhibit 2.13 will be the statement of Mr Regan.
Commissioner pleases.
Yes, yes, Mr Hogg.
Thank you, Commissioner.
No, I need that one, yeah.
Mr Regan, you're the Group Executive for AMP in relation to Advice and New Zealand, is that right?
I am indeed.
And you've been put forward by AMP as its witness to give evidence in response to a series of questions that the Commission has asked in relation to misconduct concerning fees for no service.
I have.
And you've only been in your present role since 1 January 2017,
That's correct.
but you were already a Group Executive of AMP at that time.
Yes, I was.
And as at 1 January 2017, the change was that Advice was added to your portfolio of responsibilities.
Broadly speaking, yes.
You were already the Group Executive for New Zealand?
Yes, I was the Managing Director for New Zealand, and in that role, part of the group leadership team.
I see.
But the title wasn't formally Group Executive.
I understand. And the group leadership team is also referred to as the GLT, is
It
that
is.
right? And the GLT reports to Mr Mellor.
That's correct.
Mr Mellor is the CEO of AMP.
That is correct.
And your immediate predecessor as Group Executive for Advice was Robert Caprioli.
That's correct.
But as you've indicated, you were already the Managing Director of AMP New Zealand, and in fact you've been at AMP for about 20 years, is that right?
Since the 30th of June 1999, I believe.
I see, almost 19 years. And the GLT, that also includes Brian Salter,
It does?
and Mr Salter is the General Counsel for AMP,
Yes, he is.
and he's been in that role since about 2008.
That would be approximately correct.
And Mr Mellor, in addition to being the CEO, is also the Managing Director of AMP,
That's correct.
and he was appointed as CEO in January of 2014.
I believe so.
And ultimately, the GLT is responsible for implementing the policies and strategies that are set by the AMP board.
Yes, they are.
And Mr Mellor, as Managing Director, is a member of the board.
Yes, he is.
And the current chairman of the board is Catherine Brenner,
Yes, she is.
and she's held that position as chairman since June of 2016.
I couldn't recall that off the top of my head, but it would be very close.
All right. Now, I want to ask you some questions about AMP's advice business, just to lay out the structure of it. The advice business of AMP is comprised of how many licensees?
There are 4 main licensees, and there's a further, I'll say approximately 10 or so, but I'd have to go to the list to double check the absolute number.
Right, so are the 4 main licensees AMP Financial Planning Proprietary Limited,
Yes,
Charter Financial Planning Limited,
yes,
Hillross Financial Services
Yes.
Limited? You were the previous Managing Director of Hillross, is that right?
I was up until 2000 and the end of 2006.
The 4th is AMP Direct, is that right?
No, so the other main licensee would be what was IPAC, still partly trades as IPAC, but now part of a business we called AMP Advice.
I see.
You're going to have to keep your voice up, Mr Regan.
So AMP Direct is a separate licensee.
Yes, it is.
And what is the function of AMP Direct?
AMP Direct, or what is otherwise known as AMP Assist, is essentially a contact centre style environment where we deliver responsive services to clients and provide other financial services, but typically a telephone-based environment primarily.
And how long has AMP Direct been in operation?
I'm not certain.
Was it in operation when you commenced with the business?
Yes.
Sorry, when you commenced as Group Executive for
Yes.
Advice.
Yes, it was.
Now, AMP has about 2,800 financial planners operating within its network,
Approximately.
and most of those planners are not employed by AMP or an AMP subsidiary.
No, about 90% are authorised representatives.
I see. And the other 10% are employed by, is it principally IPAC?
Yes, that's correct.
does any other licensee within the AMP group employ planners?
AMP Direct does have some employed planners, I believe.
Okay. And as you say, the vast majority then of AMP's planners are authorised representatives. Can you just explain what does that mean about the nature of their relationship with AMP?
So an authorised representative is typically a self-employed advisor as distinct from an employed advisor or representative. And so where someone is directly employed in an employment relationship with the institution, it's not anything other than an employment relationship, whereas in the case of the authorised representatives, they're licensed by the licensee. In our case, the ones that you've mentioned predominantly cover the range of authorised representatives, and they typically then have their own businesses. They're self-employed, but it's the case that they will also employ advisors themselves, but those people will also be known as authorised representatives.
We just break that down a little bit. There are authorised representatives that are companies.
There are corporate authorised representatives, so
Yes.
they are entities, yes, corporate entities.
And they might be an authorised representative of an AMP subsidiary, like AMP Financial Planning.
That's correct.
And in turn, that corporate authorised representative might employ representatives.
That's correct.
And the number of approximately 2,800, does that include representatives who are employed by a corporate authorised representative?
Yes,
Okay. So the 2,800 financial planners might be self-employed authorised representatives. That's one possibility. So you just need to say yes or no.
yes,
They might be employed directly by an AMP licensee in limited circumstances.
yes,
And they might be representatives who are employed by a corporate authorised representative.
that's correct.
And are authorised representatives commonly referred to as ARs within the AMP business?
That's correct, they would.
And the authorised representatives or the representative of a corporate authorised representative will enter into an agreement to provide financial services to a client.
Yes,
And the services that are going to be provided by the authorised representative are a matter for negotiation between the authorised representative and the client.
yes, that's correct.
And also then the price that's going to be charged for the services is a matter of negotiation between the authorised representative and the client.
That's correct.
And that would include whether or not the services are to be provided on a one-off basis or an ongoing basis.
Yes,
And if the services are to be provided on an ongoing basis, then there are specific legislative requirements that apply.
yes, that's correct.
And one legislative requirement is that the authorised representative must provide a fee disclosure statement.
That's correct.
And another legislative requirement is that the authorised representative must provide a fee renewal notice every 2 years to the client.
That's correct.
And if the client doesn't opt in to continue the services and continue paying the fee, then the fee has to stop.
That's correct.
And a very common way in which ongoing fees are paid to an authorised representative is by an automatic payment from a particular product.
Yes, that would be a typical method.
It's unusual for an authorised representative to be directly invoicing a client for fees for service.
I don't have any data to sustain the proportionality, but it would be far more common for it to be drawn in the manner that you outlined.
And so one way, as an example, that might happen is that the financial planner might suggest to the client who wants to invest some money that that money should be invested through a platform,
Yes,
and the client's money would be effectively transferred onto the platform or into the platform.
yes,
And then the advisor would cause that money to then be dispersed or invested into various, for example, a managed fund or some other investment product through the platform.
yes,
And the platform would automatically deduct an amount from the client's cash balance on a regular basis and pay it to the authorised representative.
The payment would be through to the licensee, so all monies paid to the advisor must go through the licensee in the first instance.
I see. So the platform would deduct the money from the cash balance, pay it to whichever is the relevant AMP licensee, is that right?
That's correct.
And then the AMP licensee would then on-pay it to the relevant authorised representative.
That's correct.
And can you just explain to the Commissioner what is the process by which AMP checks whether its authorised representatives are issuing fee disclosure statements?
So the fee disclosure statements are issued to the clients. They're generated through business process. The authorised representative will then just ensure that they're passed on to the client. It's then up to the authorised representative, I believe, to ensure that those fee disclosure statements are then returned to the authorised representative within 30 days of the end of the disclosure period.
And I'm sorry, does this vary depending upon whether it's a fee disclosure statement or the opt-in notice, or is the process the same?
I'm not entirely certain of the detailed process around the opt-in notice, but the opt-in notice has a similar process in that it is a 2-year period, and then there is it has to be dispatched, I think, within 60 days of the opt-in date. I'd need to verify that, but it then needs to be returned within 30 days. There is a 30-day grace period after which, or during which time, all fees must be turned off if it hasn't been returned within that 30 days.
Does AMP have any process for checking whether its authorised representatives are sending out fee disclosure statements, sending out opt-in notices, receiving opt-in notices back?
Significantly through the audit program, we would test for that.
Okay, and could you just explain then what is the audit program that AMP is operating at the moment?
So we have a audit program which addresses the audit requirements across all of the authorised representatives, and that process is effectively risk-weighted. So those advisors that are deemed higher risk are audited more frequently than those that are deemed lower risk, but typically advisors will be audited somewhere between 3 and 24 months on a rolling cycle.
Does AMP have any automatic process for checking whether an opt-in notice has been returned by a client?
I don't know the answer to that.
Right. Are you aware of any discussion within AMP about the possibility of automating the process of checking for the return of opt-in notices?
I know that we are looking at a number of projects to improve a lot of those business tasks, but I'm not entirely sure of the detail of your question.
All right. Now, I'd like to now ask you some questions about the buyer of last resort policy. Is that, it's often abbreviated as BOLR, is that typically pronounced as BOLR within the business?
Yes, it is.
All right. And you've exhibited a BOLR policy, which is tab 20 of your statement, or tab 20 of the exhibits to your statement, and the reference is AMP.6000.0007.0658.
Would you like me to go to that?
Yes, I think if you have that open,
Yes.
Mr. Regan. There is a screen next to you, Mr. Regan, if you wanted to look at it on the screen. It's up to you.
Oh, thank you.
I don't think you can flick. It's not
it's
an
not
iPad.
touchpad.
It's you only get to see what I want you to see, Mr. Regan.
Sometimes.
Yes. Well, we'll see. Sometimes we don't get to see anything that any of us want to see. Can I just ask you to explain in a very general way how the BOLR process works?
So the buyer of last resort is a facility offered, and if we talk perhaps specifically about AMP financial planning, because that's the relevant policy that you've got there, noting that there are various other buyback arrangements, but the AMP FP BOLR arrangement effectively enables an advisor to have sale-back rights to AMP under certain conditions. Those conditions vary based on the tenure of the advisors. So, for example, generally speaking, you have to be with the business for at least 4 years before you have an entitlement to sell back. That will vary for those advisors who, I believe, have more than 15 years' worth of service, in that the notice period for those people will be shorter compared to the people that are only serving or have served 4 years. It's the case then that AMP will, based on various conditions that attach to the sale-back process, and that will go to, for example, the quality of files and a range of other indicators that AMP will then undertake to buy those clients back or that register back. It'll be for, generally speaking, an agreed value of approximately 4 times the recurring or ongoing revenue of the business, regardless of whether that is made up of commissions, as in grandfathered style commissions, or payments that relate to mortgages or indeed fees. And then typically the BOLR is then subject to some notifications. So the notification, I think, has to go in initially at 6 months, and then the application has to be made around 6 to 8 months from the date of expected departure.
Let me break down some elements of that with you. Is it fair to say that within the AMP network, it's an intention of AMP that it be possible to effectively sell books of clients?
That's correct.
And the books of clients might be sold by one authorised representative to another authorised representative of
That's correct.
AMP. But if an authorised representative is unable to sell a book of clients to another authorised representative, then subject to satisfying certain conditions, AMP will buy that book of clients.
Correct.
And the BOLR policy sets out a particular method by which that book of clients is valued.
Yes.
And as you've said, typically it's valued on 4 times revenue.
That's correct.
And there's some adjustments, and we'll come to that
Yes.
in a moment. Now, the policy that's up on the screen is one that was effective as at the 1st of July 2012.
Yes.
And that continued to be the current BOLR policy of AMP financial planning until a new policy was brought in June of 2017.
I'm not entirely certain of that.
Well, if you look at tab 21 of the exhibits to your statement, that's the new policy.
I believe so. I just don't know whether there were any in between the two, that's all. I wasn't in the business at that time. I don't have first-hand knowledge. I'm not suggesting it's not. I'm just not certain that it is, that's all.
All right, well, we might come back to that. But there's been a relatively significant change between the 2012 policy and the 2017
Yes.
policy. And in a sense, one of the things that the 2017 policy tries to address is the problem of orphan clients and the charging of fees to orphan clients. Do you agree with that?
Certainly an updated policy, and it certainly looks to improve the arrangements for ongoing fee clients. Yes, I would agree with that.
Okay. Now, if we go back to this idea then of AMP buying the book of clients, is it fair to say a significant problem with that until very recently was that AMP had no capacity to be able to provide any service to those clients that it bought?
Yes, that's correct, where they are fee-paying clients.
Sorry, speak up. What did you say?
Where they're fee-paying clients.
Sorry, well, you Is that suggesting you did have capacity to service clients who weren't fee-paying clients?
Commission-based clients,
You could provide services to commission-based clients.
in a limited sense, yes, because commission-based clients don't require the same degree of servicing.
I see, they don't really require any servicing, therefore it's possible to service them.
So the servicing is more reactive.
And is what that means that AMP had a telephone call centre that you could
Yes.
call into?
That's correct.
And that telephone call centre wasn't staffed by financial planners,
Generally, no.
so they couldn't actually provide financial advice.
That's correct.
It was a purely administrative call centre.
Service-based.
I'm sorry, I'm not sure what that means.
Well, providing services to those clients, so for example, checking balances or undertaking transactions, notifications of changes of address, things of that nature.
Yes, administrative services rather than providing any advice at all.
That's correct.
And so when you say it was possible to service commission clients, that just means so long as they didn't require any advice, then AMP didn't have a problem.
That's correct.
The problem was all of the clients that were paying fees for advice.
That's correct.
And I just want to delve a little bit into the detail of the bowler policy. Can we go to page 9 of the policy, which is .0666?
So this is the July 12 or June 17
I'm sorry,
policy.
this is the July 12. I think we've got
AMP 6000 007 0658 at.
0666.
Thank you.
I think we've got the wrong document up on the screen. Thank you.
That was page 9?
Yes. That should be headed Approved Product and Services List.
That's correct.
And what this is explaining is that one aspect of the bowler policy as it applied under this policy was that you would only be paid the multiplier on revenue, or indeed paid anything for a client, if that client's products were on the approved products list.
I'm not sure I know the answer to that.
Well, if we pop out the paragraph that comes after the dashes that begins, bowler is not applicable to products that are not on the
Thank you, yes.
APSL. Do you agree with that?
Yes, thank you.
And what's also explained is where a product is on the APSL, but the related platform is not an AMP financial planning approved platform provider, the combination is considered not to be on the APSL. Is that your understanding of how the policy worked? Or do you not have any understanding of how the policy worked?
I don't have a detailed understanding. I'm familiar with the policy itself, but in terms of operationalising the policy, I've never had any material role in operationalising the bowler policy per se.
All right. Well, you understand in any event the mechanics that we've talked about already of the idea of a platform and investment in a managed
Yes,
fund.
I have, yes.
And what this appears to mean is that if a client is invested through a platform into a particular managed fund, even if the managed fund is on AMP's approved products and services list, if the platform isn't, then bowler does not apply.
I believe that's what it says, yes.
And that means, for example, if a Platinum International fund is on the approved products list, but the client has been invested in that fund through Macquarie's platform, bowler won't be applicable.
I believe that's the case.
And that's because the platforms that are available on the approved product list of AMP are primarily limited to its own brand platforms.
As it was at that time, yes.
And can I suggest that creates a very strong incentive for the advisor or the planner to place the client onto a platform on the approved product list?
Yes, noting that that was 2012.
Well, it was you're not accepting, are you, that this remained the policy up until 2017?
I'd have to check the policy to be able to confirm that.
Well, if you go to paragraph 100, or if we bring up paragraph 155 of your statement,
The question didn't make it clear when he was talking.
and can we pop that out? See, this version of the bowler policy was current until it was superseded by a revised bowler policy dated 1 June 2017.
Yes.
That was your evidence. Is that still your evidence?
Yes, it is, but does that not say that it was superseded by the revised policy on 1 June?
On 1 June 2017. So we agreed
Yes.
this is the policy that applied from July 2012 until the end of May 2017?
Yes.
Okay.
Sorry, it might have been at cross purposes.
No, that's
You
fine.
earlier said to me that you weren't sure whether there was any intervening policy. Are you now sure that there's no intervening policy?
I'm not sure, Your Honour, no.
Well, you see, you've said that what's in your statement is true. I read your statement as telling me there was a policy as at 1 July 2012, and then there was a change of policy at 1 June 2017, and I read it as saying there was nothing in the middle.
And I agree with you on having reread it.
Do go on.
Thank you, Commissioner. And are you aware, Mr. Regan, of what proportion of the platforms available on the AMP approved product list are own brand platforms?
Certainly the vast proportion.
All right. Can we go back to the 2012 bowler policy? That's tab 20 of Mr. Regan's, of the exhibits to Mr. Regan's statement. And can we go to page 28, which is the page ending .0685. Now this sets out the method of valuation that was used in order to determine the value of a book of clients. Do you have any familiarity with this method, Mr. Regan?
Not particularly, no.
Okay.
So I'm familiar with the policy, I've read through it, but as I said earlier,
All right. Well, your general understanding is that 4 times revenue is paid.
yes, that's correct.
You see in the formula that the way in which that seems to be broken down principally is that there's 4 times base ongoing commission,
Yes,
and then there's 1 times fee for service.
yes.
And perhaps a little confusingly, base ongoing commission also includes fee for service. Are you aware of that?
Fee for service is in the other part of the calculation.
Well, you recall we talked about the 2 ways in which fee for service could be charged to a client. One is by the advisor or planner directly invoicing the client, and the other is by the fees for service being automatically deducted from a product.
Yes,
And if we go to page 29 of the policy, which is the page ending .0686, and first if we blow up the section or the row which begins 1 times fee for service, you'll see a 1 times multiple will be applied to regular invoiced fee for service revenue earned by the practice in the past 12 months.
Yes.
And then if we blow up the row beginning 4 times base ongoing commission, and you see their actual ongoing commission rate for all policies classified as new book, the AOC rate will reflect the actual advice fee deducted against the policy in the 12 months prior to the valuation.
Yes.
So you understand, looking at this now, as I pointed out to you, that base ongoing commission in this formula actually includes fees for service that are automatically deducted from a product.
Yes, I think that's the case.
And if we go over to page 30, which is the page ending .0687, and blow up the second paragraph from the top beginning actual ongoing commission, and that also accords with what we're talking about, that actual ongoing commission includes ongoing planner service fees, ongoing member advice fees and plan service fees from the product.
Yes.
And so, for example, if a client is invested in a platform and the platform is automatically deducting the fee for service and paying it first to the licensee and then the licensee is paying that to the authorised representative, that automatic deduction is part of actual ongoing commission.
I believe that's the case based on that, yes.
Now, one of the things that you've said in your statement is that the intention when a client was moved into the bowler pool was that the ongoing fees that they were paying would be dialed down to just product commission.
That's correct.
That's your evidence and what you understand was the intention with respect to the policy.
Yes.
As we've seen, though, in the bowler policy, at least as it applied up until 1 June 2017, ongoing commission was defined to include fees that are being automatically deducted from a product.
Yes.
Do you know whether when the fees are being dialed down, they are dialed down to just strict commission or to what is product commission as defined by the bowler policy?
I understand it would be dialed down to just commission.
Right, are you certain about that?
No, I'm not entirely certain.
Okay. And one of the issues, if that was to occur, one of the issues that would create is that AMP would buy the book of clients from an authorised representative at 4 times the product commission, including the ongoing fees. So that's the first part. You agree with that?
Yes.
But then those fees would all disappear, and when AMP came to sell the book, it would no longer be able to sell a capitalised version of those ongoing fees.
That's correct.
So that effectively every time AMP bought back a book of clients under the bowler policy, it would lose money.
That's correct.
And because, well, I'm sorry, I'll withdraw that and break this down. From 2010, AMP tried to get ahead of the game and switch its authorised representatives over to ongoing fees rather than product commissions. Is that right?
I believe so, yes.
And so even by the time we reached 2013, a substantial amount of the revenue stream that was coming from clients of AMP authorised representatives was coming in the form of fees for service rather than commission on products? Or you're not sure?
Not substantial.
Certainly then, let's do it another way, by 2016, the substantial or a substantial amount of the fees being received in respect of clients of authorised representatives of AMP was fees for service rather than commission.
It only really turns on what you mean by substantial, but I would gather it was certainly around 30%.
Okay.
if we were to try and approximate.
And that's by 2016, is
Yes.
that right?
Yes,
And so the other 70%, that's still grandfathered commission, is that right?
that's correct.
Okay. And so when you do the dial down, you would only be dialing down the 30%, you wouldn't dial down the 70% of grandfathered commission.
That's
that right?
correct.
Okay. But in any event, there is a disparity that is created by the bowler policy if you can't keep the fees for service going on.
That's correct.
And if we then move to the next topic, which is a summary of the types of fees for no service issues that have arisen for AMP, you've identified in your statement 2 types of fees for no service issues that AMP has.
Yes,
One of those, well, the first type is a fees for no service issue at the advice licensee issue.
that's correct.
And the second type is a fees for no service issue at the advisor level.
Yes,
And the charging of fees for no service by advice licensees arises in relation to what are sometimes referred to as orphan clients.
that's correct.
And in AMP's case, every client that goes into the bowler policy is an orphan client,
Typically, yes.
because an orphan client is one that doesn't have a financial planner
That's correct.
allocated. And in addition, orphan clients have arisen in other ways for AMP. One is AMP terminated some advisors for cause,
That's correct.
and the problem was that AMP provided no services to the clients of those advisors but continued to collect fees from those clients.
That's correct.
And that was the subject of a breach report by AMP to ASIC on the 3rd of May 2017.
I think that's correct.
And that was actually, well, you can satisfy yourself based on your own evidence if you want, Mr. Regan. You refer to this at paragraph 136.
I'm
of your
aware of the
statement.
breach, just the
The
connection
date.
of that, the date, yes.
I say, and you might be confused too, because in fact, AMP gave 2 breach notices on that day to ASIC about fees for no service. You're
Yes,
aware
that's
of that?
correct.
And the second of those breach notices was in relation to ring fencing.
That's correct.
And ring fencing is another variation on how orphan clients could arise for AMP,
Yes,
which is AMP would be buying back the register of clients, but not actually putting those or that register of clients into the bowler pool.
typically with ring fencing, it was expected that there would be a sale from an exiting to an acquiring advisor, and the register was essentially held under those terms to enable that transaction to take effect.
Can we just break that down a little bit? What you're talking about is, at the time that the sale of the clients to AMP occurred, it was, in some cases, hoped, in some cases, expected that it would be possible to very quickly on-sell those clients to another authorised representative,
Yes,
and that the desire was to sell that entire book or register of clients in whole to that other authorised representative.
generally, yes.
But the authorised representative wasn't in a position to buy those clients on the day that the transaction took place, or the purchase by AMP
Yes.
took place. And it might be that AMP anticipated that in a few weeks' time it would be able to sell the clients. It might be that it just had a hope that at some time, some unknown time in the future, it would be able to sell the clients.
Typically with ring fencing, there was an expected transaction to occur.
Okay. But not necessarily a date of that transaction.
That's correct.
And so the clients would be ring-fenced, meaning they don't go into the bowler pool, but they keep paying fees,
That's correct.
even though nobody is providing them with any services.
That's correct.
All right. And that was the second breach notice that AMP gave to ASIC on the 3rd of May 2017.
Yes.
Now, on the other hand, the charging of fees for no service by advisors is simply that the advisor doesn't provide any services to the client, even though the advisor is contracted with the client to provide the services.
Yes, they will be receiving a payment, but haven't provided the services in those instances where that occurs.
Or AMP is probably receiving the payment, isn't it?
That's correct.
And then remitting that
That's
payment to
correct.
the planner. But the planner isn't actually providing the services.
That's correct.
All right. And the only way that AMP would pick that up is by doing an audit of the advisor's practice.
Generally, yes.
What's the other way that it could pick it up?
It may be as a result of a complaint from a client, for example, but generally speaking, we didn't have systems in place to monitor those payments.
Okay. Now, I want to then move to another topic, which is your recognition of problems in the business on your appointment. Upon your appointment as the group executive for advice, it became apparent to you that there were significant problems with the governance and oversight of AMP's advice business.
Yes,
And one of the things that alerted you to this was that ASIC had issued 112 notices to the AMP group in 2016 seeking production of documents.
that's correct.
And of those, 85 notices went to AMP Financial Planning,
Yes, that's correct.
just the one licensee.
That's correct.
And ASIC had also required 18 current and former AMP employees and AMP Financial Planning planners to attend compulsory examinations in 2016.
I haven't got the number in front of me, but that sounds correct.
And do you know, were all of those people connected with the advice business?
I couldn't be certain. They would be in some form or another related to the advice business, yes.
Okay. And that was apparent to you as at 1 January 2017 when you took over?
Not immediately, but I mean, progressively
soon.
through, yes, yes.
And as we're going to see, the scale of the problem got worse.
Yes,
Now, one of the things that you've said in your statement at paragraphs 31 and 32 is that, and I'll break this down. First, ASIC issued a notice to AMP Financial Planning dated the 3rd of April 2017 requiring AMP Financial Planning to produce certain documents.
yes,
Second, those documents were located over a period up until about the 20th of May 2017.
yes,
Third, those documents were then brought to the attention of the AMP General Counsel of Dispute Resolution.
that's correct.
And what is her name?
Larissa Baker-Cook,
Thank you. And fourth, she in turn brought those documents to the attention of Mr. Salter,
that's correct.
the General Counsel of AMP.
That's correct.
And then together they informed you of the documents sometime before the 19th of May 2017.
I think it was perhaps, but we met on the 19th of May to discuss the documents.
And you met and discussed them on the 19th. And did Clayton Utes also attend that meeting?
Yes, I believe they did.
And we'll come in a moment to what happens after that. But what were the documents that had caused this issue to be elevated up to you?
There was a series of emails that were concerning in relation to the knowledge of approving the continuation of fees and comments that people had made about the appropriateness of that. Secondly, there was a document related, as I recall, to a particular project that was linked to the FOFA program of change. and there were emails related to specific legal advices suggesting or outlining particular advices in respect to the ability to charge fees under circumstances where the services weren't being provided. I can't recall if there are others, but they're examples of what we discussed.
All right, and I'll just ask you a few questions about that, and then no doubt we will come to some of these documents. The project document that you're talking about, was that a document that was prepared by Brian Magellan?
Yes, that's the document I'm referring to. And I
Okay.
think that was shown to us on the day.
I see. And the specific legal advices, are they internal legal advices from internal lawyers at AMP?
Yes.
Saying if you bring a client into Bowler, you have to turn off the fees for them?
The legal advices were related to particular instances where inquiries had been made of legal, for example, in relation to the ability to retain the fees without services being provided on an exceptions type basis.
Perhaps we'll do this by reference to some documents, but I just want to understand was there some novel thing that you became alerted to as a result of seeing those legal advices? Some novel proposition?
The issue that was being canvassed was what's become known as the 90-day exception,
Yes,
if that's what you were getting at in terms of the novel.
I understand. Is it, was it and what you're referring to then is there were emails you saw which were effectively making clear there is no lawful basis for implementing what's referred to as the 90-day exception?
That is consistent with the advice, yes.
And when you saw that, were you already aware of the 90-day exception at that time?
The 90-day exception had been raised as an issue in relation to a matter that had been reported to ASIC.
Yes, it had already been reported at
That's
the end of
correct.
the previous year.
Yeah,
And the 90-day exception, as you've explained it, was an exception where fees would be left on in the bowler pool for up to 90 days after the client had been moved into the bowler pool. Is that right? Sorry, again, just because it's being recorded.
could you repeat the question?
Yes, that the fees will be left on for a client for up to 90 days after the client went into the bowler pool. Is that right?
Yes,
Okay. And the legal advisors, internal legal advisors, said there's no lawful basis for doing that.
that's correct.
Did that come as a surprise to you, that there was no lawful basis for doing that?
No, it's not a surprise that it's not lawful.
It's just obvious, isn't it, that you
Yes.
can't charge somebody for 90 days for providing services that you're not going to provide. You agree with that?
That's correct.
All right. And so then, whatever the particular matter is, was something you then felt you needed to bring to the attention of the CEO?
Well, this is in the context of the meeting that Larissa, Mr Mavrakis, Mr Salter and I had on that day,
Yes.
where we became aware of these.
And what is it then that you are going to meet with the CEO to inform the CEO about?
To make him aware of those advices, to make him aware of the circumstances that we'd come across in relation to the legal advices, the other documents that I referred to, and so on.
Right, so you see in the middle of paragraph 32, you say the Group General Counsel and I then raised the matter immediately with the CEO.
Yes.
So just, if you can, just tell the Commissioner, what is the matter that you're referring to there?
This is the issue of being made aware of the legal advices along with the other documents that I referred to,
And,
and that there had been legal advice provided in that regard.
okay. So is the issue, I'm not trying to trick you here, Mr. Regan. I'm just trying to understand what it is that was so novel that struck you and Mr. Salter on the 19th of May. Was it that employees lower down the chain than you had been specifically advised that it was not lawful to continue fees for 90 days?
No, that matter had been dealt with previously, so the 90-day exception, as it was known, and in fact there was a direction to cease that in November of 2016.
Yes. So what was the novel point that had arisen that you felt you needed to immediately inform the CEO of?
That there was specific legal advice showing that people had approved some of these things against legal advice.
Oh, I see. That is, they'd been specifically advised it's not lawful to implement this 90-day exception, and they just went ahead and implemented the 90-day exception. And that was the point of particular concern.
That's correct. It had previously been described as an administrative oversight. What was different is that we became aware that it was a conscious business practice.
Now, that can't be right, because you already knew, as at the end of 2016, that it was a conscious business practice, didn't you? That was why you'd given another notice to ASIC.
It was identified as a commercial practice.
Yes. But that had already occurred as at the end of 2016.
Yes, that's correct.
Right. So was the novelty just to discover that this commercial practice had been, which you already knew about, had been implemented in the face of legal advice?
Yes, that's correct, I think, in part, yes.
Well, I just want to understand, when you say the Group General Counsel and I then raised the matter immediately with the CEO, what is the matter that you are raising with the CEO?
So there was the specific issues in relation to the exceptions that had been approved without, what we understood to be against legal advice. But there was also as I recall, the practice proposition stream document which indicated that it might have been formally approved through a process.
I see.
And yes.
Okay.
So I did have something else, but I've forgotten.
That's right. Do you need to think about it?
No, it's fine.
Okay. And then in turn, that was raised with the board of AMP?
That's correct.
And ultimately then AMP commissioned Clayton Utes to provide a report,
That's correct.
and Clayton Utes was asked to investigate what was occurring in relation to the bowler policy and ring fencing,
Yes.
and also,
Well,
I'm sorry,
Yes.
and also to investigate the reporting of these matters to ASIC.
Yes.
All right. Now, at paragraph 46 of your statement, we just bring that up. You make an apology on behalf of AMP,
I do.
and you say, "I apologise unreservedly for the failings in respect of advice and service delivery to our clients and for the regulatory breaches which are discussed below." What are the regulatory breaches that you, on behalf of AMP, are apologising for?
The various breaches of the Corporations Act that have been incurred as a result of these practices.
Or do you know what specific breaches they are?
I don't have them to hand.
Okay.
Yeah.
Do you know whether before this moment, when you've said that AMP is apologising for specific breaches of the Corporations Act, AMP has acknowledged that it has actually breached the Corporations Act in relation to this conduct?
Yes, I think we accept that we have.
You think you have accepted that you have? I'll just show you your submissions on behalf of AMP. Can we bring up RCD.0001.003.0003? Have you read the submissions made by AMP to the Royal Commission?
I've read the witness statement and I've been through the various exhibits.
I see. Perhaps what we might do it by reference to is RCD.0001.0033.0041. Have you seen this document before, Mr. Regan?
Possible to make it larger.
Can we,
Thank
thank you.
I can't recall it from the attachment itself.
All right. Well, if we go to page 3 of that document, page 3 of 6. If you just zoom in on there, you see this is the fees for no service, the licensees issue that you referred to.
Yes.
And you see what's said on behalf of AMP is the conduct involves possible contraventions of various provisions of the Corporations Act and provisions of the ASIC Act. Do I understand that you are now saying we should, or the Commissioner should ignore the word possible, that AMP acknowledges that there were contraventions of the Corporations Act by AMP?
No,
No. So,
I don't believe we've acknowledged that, we've admitted those as yet.
okay. So when you say you're apologising for regulatory breaches, what are you apologising for? What breaches?
Well, for example, we know that we have committed breaches in relation to retaining fees on client accounts where fees have been charged where they shouldn't, and we know that that is a breach. So that is a breach of our licence condition, and that's what I'm apologising for.
I see, you're apologising for breaching your licence
That's
condition?
correct.
And what is the particular condition that you're apologising for breaching?
That which relates to our inability to charge those fees where otherwise the services aren't being provided.
Well, that's not a licence condition of your licence, is it?
I believe we have to act honestly, efficiently and fairly.
All right, so are you acknowledging, is AMP acknowledging that it has failed to act honestly, fairly and efficiently in relation to the charging of fees for no service?
Yes, we have.
Okay. Sorry, when you say yes, we have, are you aware of ever having done it before now, this very moment when you've done it?
Yes, I'm uncertain.
All right. If you look at, I'm sorry, do you know what the statutory source is of the obligation to act honestly, fairly and efficiently?
Corporations Act.
You know it's section 912, capital A, 1A of the Corporations Act?
Not exactly, but Sounds right.
Take my word for it.
Yeah.
And you see, if you go back to the submission that it's in front of you, what's said is the conduct involves possible contravention of, and then one of the sections is 912 capital A 1A.
Yes.
So I just want to be fair to you. The submission that has been made by AMP to the Royal Commission is that it's possible that it might have contravened this section.
Yes.
Are you changing that position? No. Okay. So we can eliminate then that you're apologising for a breach of the requirement to act honestly, efficiently and fairly. What else are you apologising or not apologising for?
So we did issue a breach notice, which is acknowledged as part of what we laid out earlier. So you go back to the breach notices, the 5 breach notices that relate to the charging of fees under circumstances where that wasn't permissible.
Sorry, you've issued a breach notice. Is it your understanding that by issuing a breach notice you're admitting a breach of the statutory obligation?
I'm uncertain of that.
Okay.
Yep.
You know, and we're going to come in some detail to the fact that AMP did not notify ASIC in relation to these potential breaches. You know that there was a significant delay in giving notification to ASIC and that a number of the communications given to ASIC were false or misleading.
That's correct.
And are you apologising for some misconduct in relation to that?
Yes.
Okay.
Yes, we are.
Again, if we go then to page 4 of 6 of that table, and can we blow up the last row? You'll see what was said in that submission was there was possible misconduct in relation to the extent and nature of AMP's reporting to ASIC in relation to fees for no service licensees. Can the Commissioner now take it that the word possible no longer applies, that you are acknowledging on behalf of AMP that there was actual misconduct?
I'm uncertain.
All right. Doing the best you can, when you say in paragraph 46 of your statement, on behalf of AMP, I apologise unreservedly for the failings in respect of advice and service delivery to our customers and for the regulatory breaches which are discussed below, what is it that you are apologising for?
For the failure to deliver those services to those clients.
Okay, so that's the first part of the statement. And in relation to the regulatory breaches which are discussed below, do you know what it is that you're apologising for?
Well, does my friend mean the facts or the legal conclusions? Because there's a significant difference, and this gentleman's not a lawyer, so I think it's leading to some confusion with respect.
Well, Mr. Crutchfield, what am I to do about the fact that this is his statement, paragraph 46? What am I to make of it? I thought that's what counsel was exploring.
Yes, sure, but Mr. Regan's already said he had nothing to do with the preparation of the submission to the Commission, and that document contains legal conclusions, and it's manifest this witness is not in a position to do
Mr. Hodge was examining the witness about the content of paragraph 46 of his statement. Is there
Yes.
any difficulty about that?
Absolutely not.
No, do go on, Mr. Hodge.
Thank you, Commissioner. When you say, Mr. Regan, on behalf of AMP, I apologise unreservedly, relevantly, for the regulatory breaches which are discussed below, what are you apologising for?
I'll have to take that on notice.
Afraid that's not really how it works. Is the answer you just don't know?
Yes, I'm uncertain.
Was this apology agreed to by the board of AMP?
This is my witness statement.
Did the board of AMP, as far as you're aware, resolve to make an apology?
No, I didn't seek their approval to make the apology.
All right, and they didn't authorise you to do so?
Well, I'm authorised to give the witness statement.
Was the apology something that was, to your knowledge, discussed by any committee of AMP?
Not that I'm aware of.
Was there anybody else employed by AMP who was involved in the drafting of your statement?
Yes.
And who was that?
Our legal team?
Okay. Was Mr. Salter involved in the drafting of your statement?
He would have been, he certainly was familiar with the statement. Yes, he was involved with the statement.
Right. Was Mr. Mellor involved in the drafting of your statement?
Mr. Mellor has seen a draft version of the statement, I believe.
Right. Did he provide any comments on your statement?
Yes, I believe he would have.
Was Ms. Brenner involved in the drafting of your statement?
I'm not aware that she was.
I'd like to move now to a different topic, Mr. Regan. And as you know, Clayton Utes reviewed many documents for the purposes of preparing a report for AMP.
Yes.
Have you looked at the documents that Clayton Utes reviewed?
Not all of the documents, I don't believe, no.
But some of them?
Yes.
Okay. Now, the first time AMP gave a significant breach notice to ASIC in relation to orphan clients was in 2009. It's not a trick. We'll bring up the document. It's AMP.9000.0001.1460.
I believe that's
Sorry,
correct.
what was the number, Mr. Hodge?
I'm sorry, it's
900001.
.1460.
Thank you.
And it's actually an exhibit to your statement, Mr. Regan. It's tab 33 to your statement.
Thank you.
So this is a notification given pursuant to section 912D on the 15th of January 2009.
Yes.
And you're familiar with it, obviously? You've looked at it, you've exhibited
Yes,
it to your
I have
statement?
had a look at it, yes.
And it gives notification that clients were being charged an additional fee for service where what they were paying was dialed up above base commission,
That's correct.
and that when they were then, when the advisor or planner left and the client was transferred either to another planner or alternatively into the bowler pool, that they continued to be charged this dialed up commission but no services were provided to them.
Yes, I understand that's the basis of the breach.
All right. Well, that was the notification that was given
Yes.
in 2009.
Yep.
And what's explained as to the reasons for this was that there was an absence of adequate monitoring arrangements. We see that on page 2, which is 1460_0001. You see there was an absence of monitoring arrangements in place to ensure that this activity was followed.
What was that number again?
Now, if you just look about 2/3 of the way down the page, do you see the sentence, there was an absence of monitoring arrangements in place to ensure that this
Yes.
activity was followed?
Yes.
And what AMP said it was going to do, and we go to page 4, which is _003, was to put in place detailed processes relating to the adjustment of additional fees when a client's servicing rights are surrendered back to AMP-FP under a bowler arrangement. You see that?
Yes.
And ensure relevant staff receive training on the new procedures.
Mm.
Again, just because it's being recorded, you'll need to
Yes.
say yes or no. And then you see the third thing was to put into place monitoring controls in our risk and control system covering compliance with the above mentioned process.
Yes.
And you're obviously aware of this document, you've looked at it, you've exhibited it to your statement. Have you gone back to try to understand why since 2000, or whether and to what extent since 2009 any of those three things occurred?
I wasn't obviously in the business for a lot of that period of time, but that said, we've obviously had other similar breaches since then. I believe in 2013 and 2015, so this has occurred on a number of occasions. What we have done in more recent times is implemented a number of reviews to try and investigate, to put improvements into place in relation to these types of controls.
We should be clear about this. This problem has been occurring continuously at AMP since 2009, hasn't it?
Yes, that's correct.
And my question was, have you gone back to look at the extent to which there was an attempt to do any of these three things?
No,
Okay,
not specifically on those, no.
all right. Now, you agreed with me that the problem had been occurring continuously since 2009. To make good that proposition, can we, I'm sorry, Commissioner, I don't need to tender that document. To make good that proposition, can we go to document AMP.0094.4475? And you'll see this is a chain of emails from 2011, Mr. Regan.
Yes.
It's 2 pages long. Can we bring both pages up on the screen? Thank you. Is this a document that you've looked at before now?
Yes.
Okay. And so you know, if we go to the first email in time, which is one sent by Anne Singh on the 7th of January 2011, that she has raised an issue, which is when we buy back a partial or full book from a financial planner, which is Bowler, one of our processes is to request the removal of any fees that were dialed up by the previous planner above the standard fee. In 2008, we identified that this had not occurred and lodged a compliance breach. And then it goes down and says, under the heading issue, we have now identified that there are gaps in the process. So that was how this kicked off.
Yes, that's correct.
And then over the page, an email is then sent by Ms. Snedden to Mr. Guggenheimer and Mr. Helmick, saying, just wanted to give you a heads up on this issue. And a draft ASIC letter has been prepared by Group Risk and Compliance, and this is currently being reviewed by legal. You see that? And oddly, the response from Mr. Guggenheimer is, Deb, I'd like to challenge the notion of this being a breach. It's not an AFSL requirement, it's a business rule. Happy to chat about it if you need any context to help discussions with legal.
Yes.
And as it turned out, no breach notice was ever given to ASIC in 2011 in relation to this.
That's correct.
Do you know why no breach notice was given to ASIC in 2011?
As I understand it, there was a decision taken based on legal advice not to issue the breach notice.
Who made that decision?
I'm uncertain of that.
What is the basis for your belief that somebody made that decision?
I've been advised of that.
By whom?
Miss Baker Cook, I believe.
Okay. Is she in the legal department at that time?
No,
I see. So she's been told by somebody else?
that's correct.
Is there any record kept within AMP as to the decision making or the making of decisions about whether or not to give a breach notice?
There is, yes. I don't know the history of it, but certainly there's a breach committee process which is documented today.
What was Mr. Helmick's role at that time?
Mr Helmich, I believe, would have been in a role responsible for all of the advice licensees at that time. I can't recall the title, but it would be a role of that nature.
Is it the practice now of AMP to document a decision as to whether a breach notification is or is not given to ASIC?
I'm not familiar firsthand with the process. I'm not part of the breach committee process.
And it's fair to say, isn't it, the problem of charging fees to clients sitting in the bowler pool continued to be an issue in 2013?
Yes, that's correct.
And I'm sorry, Commissioner, I should tender that document.
Exhibit 2.14 will be emails January 2011 concerning approval of dial-up fees for Bar of Last Resort AMP 0001 0094 4475.
Thank you. Now, Commissioner, I'm sorry, Mr. Regan, I'll show you now a document which is AMP.0001.0092.7314. Now you'll see this is a program steering committee pack from the 6th of May 2013. Are you familiar with exactly what the structural arrangement was in 2013 in relation to this program steering committee?
I believe Mr Mellor was the chair of that committee, and a number of the attendees would have been members of that steering committee.
And was the aim of the committee, or was the purpose of the committee, to get AMP ready for the changes that were about to come under the Future of Financial Advice amendments?
I believe so.
All right. And as you said, Mr Mellor, who is now the CEO, is the chair of the committee, and you're saying you think the attendees listed there were the other members of the committee?
I'm not entirely sure of the composition of the committee, but I'm sure it would be from amongst those attendees.
All right. But in any event, we can see there that Mr Caprioli, your predecessor, was an attendee at that meeting.
Yes.
And if we go to page 7326 of that document, you'll see this is a memorandum to the committee from Mr Himmelhock. What was Mr Himmelhock's role at that time?
I'm uncertain of his title, but I'm sure it's in one of the documents there.
All right. Well, in any event, if we bring up, can we bring up next to that page, page 7330? And can we blow up the paragraph about 2/3 of the way down the page, beginning with respect to our orphan books? So this is a report to that committee explaining that, as at that time, our initial analysis indicates that there are quite a number of accounts with dial-ups and other ongoing fee arrangements in place. And then it goes on to say, once data accuracy in this area is confirmed, we'll be making a recommendation to the PPSC, that's the steering committee, in relation to options. For example, either dial all fees back to the base level commission or establish a servicing arrangement with the client.
It's a different committee, though. So the recommendation is to the Practice Proposition Steering Committee, not the one that's referred to in this document, or that this document's a subject of.
Well, this is a report to the Program Steering Committee, isn't it?
That's correct.
And the Program Steering Committee is the one chaired by Mr Mellor.
Program committee is, that's correct.
So the report at this time that's being made to the program steering committee is, part of it is, we've identified that we're still charging fees to orphan clients sitting in the bowler
Yes.
pool. And they'll be making a recommendation to, as you say, the PPSC, which is a different steering committee.
That's correct. It's a subgroup.
And that's a subcommittee under this overarching committee
Yes.
chaired by Mr. Mellor,
Yes.
as to what exactly it is that's going to happen or how this should be dealt with.
Yes.
All right. Can I tender that document, Commissioner?
Exhibit 2.15 will be Future of Financial Advice Program Steering Committee, PAC 6 May 2013, AMP 0001 0092 7314.
Now, I think we've agreed about this already, but I'll just confirm this with you, Mr. Regan. The obvious problem with charging fees to clients that are sitting in the bowler is that they're not receiving any services.
Yes.
And certainly from your perspective, there's no dispute that there was no capacity of AMP to provide services to the clients sitting in the bowler pool.
That's correct.
That's something that very recently AMP has attempted to address.
There have been attempts to do servicing of clients for that purpose in the past, as I understand, but we are undertaking a program now.
Now, there was a lot of internal legal advice, which I think you've already referred to as being concerning, that charging clients in the bowler pool for services that they could not possibly be receiving was unlawful.
Mhm.
Again, just because it's been...
Yes.
And I think you've agreed with me that advice, when you saw it, didn't come as a surprise to you.
That's correct.
It's obvious that it's not lawful to be charging somebody for services you're not providing.
That's correct.
All right. Can we just, to understand the extent of this advice, can I show you first AMP.0001.0016.7990? Now, this is an email from Tom Galetta, who was a solicitor at AMP at the time the email was sent.
Yes.
And the email's not dated, but Clayton Utes have identified it as being sent in approximately 2010, which is at paragraph 71B of their report. Can I just ask that the middle section of the email be blown up, which begins, "If you want to maintain the planner service fee"?
Mhm.
Where what Mr. Galetta says is, if you want to maintain the planner service fee, you need to provide the client with the services that the former planner agreed to provide and the client agreed to pay for, which you and I have already agreed is an unsurprising proposition. Can we just agree on the reasons for that? The first is, obviously, as a matter of contract, that's what's been agreed between the planner and the client.
Yes.
That this is what will be provided and what will be charged for it. The second is, you understand that as a matter of statutory obligation, a licensee cannot be charging for financial services that it either intends not to provide or knows are not to be provided.
That's correct.
And the third is, can I suggest, just a matter of basic ethics and morality, that you would not be charging for something that you know you're not going to provide.
I
Do you
agree.
And then Mr. Galetta suggests as an alternative in the next paragraph to be upfront with the client and to effectively say to the client, we're now going to provide something different to you. That alternative, being upfront with the client, wasn't a plan that was taken up by AMP.
Mhm.
Do you
Yes.
agree? Attend to that document, Commissioner.
Exhibit 2.16, email letter to Steinthal. Could I date it approximately 2010?
Yes, Commissioner.
AMP 0001 0016790.
Thank you, Commissioner. So that's legal advice dating all the way back to 2010. What happens in 2015 is that AMP begins an internal investigation into the charging of fees for no service to the client sitting in the bowler pool. Is that right? In 2015?
This is in relation to the breach notice lodged?
Yes, before the breach notice is
Yes.
given, an investigation
As
is
I
commenced.
understand it, yes, that's the case.
And the reason that an investigation commences is because there was public reporting of ANZ having charged fees for no service.
I understand that was the trigger, yes.
Now, when that internal investigation begins, there are a lot of emails that pass between various people, in particular Mr. Morgan, Mr. Caprioli, Mr. Paff and Ms. Turner.
Yes,
And you're familiar with those documents?
yes, I'm familiar with documents, yes.
Can we bring up AMP.0001.0043.4407? Now, this is an email from Ms. Turner, who is the legal manager for advice. Is that
Yes,
right?
that's correct. Well, was that at that time?
And it's being sent to Wayne Marsh. What was Mr. Marsh's role?
I believe he was in a role that was involved with the buyback arrangements. His title, I'm not exactly sure.
Okay. And it's copied to Mr. Morgan, and it has an attachment, which is a document titled Ongoing Services Fees. Sorry, Ongoing Service Fees.
Mm-hmm.
Again, Mr. Regan, because it's being
Yes.
recorded, you need to say yes or no. Thank you. And Ms. Turner on the 19th of May is raising a concern, which is we have well past the 10-day reporting period, so I want to expedite the breach reporting decision.
Yes,
And if we go to the attachment, which begins at amp.0001.0043.4408, so this is the document that Ms. Turner was attaching, and can we bring up on the screen 2 pages? The first is .4409, the second is .4410. And can we blow up the last paragraph of 4409 and put below it the first paragraph on 4410? So what's set out in the memorandum is that until 12 months ago, the business practice of AMP licensees was to leave ongoing advice fees in place in the expectation that advised customers would be placed with a new advisor. 12 months ago, AMP brought together all its licensee support infrastructure into single centres of excellence. An early commercial focus was to ensure that ongoing service fees on advised customers were immediately cancelled and the customer needed to renegotiate the ongoing fee arrangement with their new financial advisor. Are you aware of what the basis is for the statement that things changed 12 months before the date of this document?
no,
And you haven't seen anything that would suggest that there was some change in the middle of 2014?
I wasn't involved, but around the middle of 2014 was the implementation of FOFA.
No, that was the middle of 2013.
That's correct, that was the legislation effective date, yes. I thought there was a facilitative period, but,
All right.
yep.
But in any event, as part of the investigations that have been carried out at your request and by people under you, you haven't seen anything to indicate some change in mid-2014?
Not
at
that I
AMP?
can recall.
All right. And what if we then go to page 4415, and can we blow up the line beginning when plans are required and include the comment next to it? So what seems to have happened is this paper was originally prepared by Mr. Morgan. Is that your understanding?
I'm not sure.
All right, but in any event, there was a paper prepared and then a comment made on it by Ms. Turner. You know that that comment is by Ms. Turner?
I don't know that it is.
All right. Well, in any event, what's set out is when plans are required under a licensee buyback, the current business rule is that advice and servicing fees be turned off within 3 months. And the comment is, this is a rule that has been set arbitrarily. There is no legal basis for the period of 3 months. This rule will probably need to be revised.
Yes.
Now, I realise I repeated this a number of times. That doesn't surprise you, the idea that there be no legal basis for 3 months.
That's correct.
And you wouldn't expect that to come as a surprise to any other senior executive in the business, would you?
I don't know whether I can speak for their mind, but, and it would depend, I imagine, on whether they've received legal advice.
You didn't need to receive legal advice to know that you can't charge somebody for services that you're not providing. You agree with that?
Yes, I agree with that.
And for example, you would expect your predecessor, Mr. Caprioli, to have the same understanding?
I can't speak for Mr. Caprioli.
All right. You're aware that the Clayton Utes report is at great pains to say that there is no evidence that Ms. Turner's email was provided to Mr. Caprioli? This email with the attachment?
Sorry, what was the question?
You're aware that the Clayton Utes report is at great pains to say that there is no evidence that Ms. Turner's email was provided to Mr. Caprioli.
Yes, I understand that's what it says.
And do you know why such an emphasis is placed upon the proposition that there's no evidence that this email was provided to Mr. Caprioli?
I don't know whether there was particular emphasis.
Do you know why? I'll withdraw that. Are you aware of any reason for Clayton Utes to make a particular point that there was no evidence that this email was provided to Mr. Caprioli?
I know that was part of the work that Clayton Utes did to establish who was given that legal advice. So I assume it's because of that.
Right. I tender that document, Commissioner.
Yep.
Exhibit 2.17, email Turner to Marsh and Morgan, 19 May 15, with attachment concerning ongoing service fees, BOLR and orphans.
Thank you.
AMP 0001 0043 4407.
And then there was a chain of emails between Mr. Morgan and Mr. Caprioli copied to Mr. Paff and Mr. Guggenheimer, which I'll ask be brought up. It's AMP.0001.0016.7288. You've seen this document before.
Yes.
And Mr. Morgan is emailing Mr. Caprioli and he says that he understands Mr. Paff has already provided a high-level overview of the issue in relation to ongoing advice fees.
Yes.
And I'd like to blow up the dot points at the top of the second page if we can. Now, the first full point there, which is our historic business rule around retaining fees for 3 months since amended and allowing client registers to be ring-fenced for future sale, carries with it an inherent risk of the fees not being removed. Are you, or do you have any understanding as to what the supposed amendment was to the business rule that's referred to there?
Not in the specific, no.
Okay. But do you agree with me, what must be known to every recipient of this email is that there was a business rule around retaining fees for 3 months? That's the first thing.
Yes.
And also that there was some process in which registers were ring-fenced for future sales.
Yes.
And also that each of those things, the business rule and the ring fencing of registers, carried with it, or with them, an inherent risk of the fees not being removed.
Yes.
And that must be obvious, you would agree, to anyone receiving that email.
Yes.
I tender that document, Commissioner.
Exhibit 2.18, email 20 May 2015, Morgan to Caprioli and others, AMP 000100167288.
Now, Clayton Utes were asked to investigate 2 specific misrepresentations that AMP had identified that had been made to ASIC. Do you agree with that?
Yes.
And in addition, Clayton Utes identified a further 5 what they termed mistaken representations to ASIC by AMP.
Yes.
I want to take you through the false and misleading statements that AMP made to ASIC. Can we bring up first AMP.6000.0001.1469, which is tab 24 of Mr. Regan's statement? So this is the initial breach notice that was given by AMP to ASIC on the 27th of May 2015.
Yes.
And you're familiar with it, you've exhibited it to your statement.
Yes.
Right. And if we go to page 2, if we blow up first the first paragraph, you see the last sentence says, in the situation of this breach report, the services did not include the provision of personal advice by way of a review or any other scenario of personal advice.
Yes.
And that was untrue, wasn't it?
Yes, I believe it was.
Because, in fact, for at least some of these clients, their service that they were paying for did include personal advice.
Yes, reviews.
And then if we blow up the section headed protocols and the paragraph beneath it, and this says that internal protocols had been in place to turn off fees when a financial planning register had been purchased by an advice licensee. And then if we take that down and bring up the section under the issues, it says the processes between the advice licensees and the product administrators have failed in some instances. And that was the second false or misleading statement made in this notice to ASIC. processes didn't fail, did they, Mr. Regan? There was a deliberate decision made by AMP to retain fees on some of these clients.
As I recall, I think it's both.
In some cases, there was a failure of process, but in other cases, it was a deliberate decision by
That's correct.
AMP. And AMP didn't tell ASIC that they had made this deliberate decision.
That's correct.
And then, if we bring up the third page of the notice and blow up the last paragraph under timing of this notice, it says the issue was initially identified in AMP Financial Planning and Hill Ross about 1 month ago, and they are therefore reporting outside of the 10 business day requirement, as it has taken some time to identify if there actually was an issue. And that statement is completely false, isn't it?
Yes, I think it is.
So those are the first three false or misleading statements that AMP made to ASIC. Can we now bring up AMP.0001.044.2936? Now, this is a letter from AMP to ASIC dated the 19th of June 2017. So you'll need to say yes or no.
Oh, yes, sorry, I was waiting for, I thought the question was still going.
I'm just confirming this is,
Right.
that's what this document is. Have you seen this document before?
Yes,
And under the heading summary, you see it says, we are in the process of reviewing about 29,000 client files dating back to July 2010, where we have cause to believe our processes may have failed and fees not turned off. You see
Yes.
that? And do you agree with me that statement was also misleading because there was no reference or explanation that in fact in some cases it wasn't a failure of process, it was a deliberate decision that had been made by AMP?
I have in fact asked for that matter to be investigated. I became aware of that wording and then I have asked the Chief Risk Officer to investigate the circumstances behind that wording and whether or not we have in fact taken that to ASIC and clarified that situation. I'm not aware of the status of that today.
No, but if you just listen to my question,
The answer to your question is yes.
thank you. And then if we bring up page .2938, and can we blow up the section under number 3, fix the processes that failed? You see it says interim processes have been put in place to ensure no new clients are added during this remediation period.
Yes.
Can I suggest that was also misleading because in fact AMP was continuing with the 90-day exception and ring fencing at this time?
That's correct.
I tender that document, Commissioner.
It will be letter AMP to ASIC dated, Mr Hodge,
19th of June 2000.
19 June 17, 0001 00442936.
Sorry, Commissioner, I think that's an error. I think it should be 15. We agree that should be 15.
15 June,
19 June 2015.
sorry, what,
19 June 2015.
15,
Thank you.
sorry, 19 June 15, I know I'm innumerate. Exhibit 2.19.
Thank you. And then if we can bring up AMP.100000001.8517. This is a letter from AMP to ASIC dated the 31st of October, 31st of August 2015.
Yes.
And can we bring up page 2, which ends in .8518? And can we blow up the section under the heading Advised Customers? And you see in the second paragraph, from July 2010 to December 2013, the licensees allowed fees to continue for up to 3 months for a transition to complete. And then 2 paragraphs down, since January 2014, the commercial practice changed and fee arrangements have been cancelled immediately the licensee acquires the account.
Yes.
And that was just false, wasn't it?
Yes.
So that was the 6th false or misleading statement that ASIC had made up until this point in time.
But AMP had made to ASIC.
AMP, sorry, had made to ASIC. I tender that document.
Exhibit 2.20, letter AMP to ASIC 31 August 2015, AMP 100000016517.
Thank you. Now, can I suggest to you the fact that this process, or the fact that the 3-month rule was still in application was, it's now turned out well known within the company?
Yes.
And I want to just understand, as you understand it at the moment, how high up that knowledge went. It certainly extended up to Mr. Guggenheimer.
Yes.
And Mr. Guggenheimer at the time was the managing director of AMP Financial Planning Proprietary Limited.
Yes.
And who did Mr. Guggenheimer report to?
Mr. Caprioli.
And Mr. Caprioli was the group executive for advice and banking at the time.
That's correct.
And is it your understanding that Mr. Caprioli was aware of the 3-month rule?
I'm not certain of that, no.
All right, well, we've seen already an email that Mr. Morgan sent that referred to this rule, although he does refer to it as a historic rule. Are you aware of any other document that might have alerted Mr. Caprioli to the existence of the rule?
Not that I'm aware of.
Are you aware of any document that might have alerted Mr. Mellor to the existence of the rule?
No.
Have you looked at the internal audit report in 2014 for
Yes, I
AMP?
have.
All right. Could we bring up AMP.6000.0006.4372? And that's tab 26, I believe, Mr. Regan, of your statement.
Yep.
You've obviously looked at it before.
Yeah.
And can we go to page 8 of that internal audit report, which is the page ending .4379? And blow up the section under the underlined heading ongoing fee arrangements.
Mm.
And you see there's an explanation that the introduction of the FOFA fee disclosure statement obligations has created additional considerations during the purchase and sale of client registers. selling planners are now required to submit an OFA, which is an ongoing fee agreement, listing which provides their clients fee disclosure information and last fee disclosure statement issue date. Planners are also required to provide fee disclosure statements to clients where appropriate for a period of up to 3 months post the intended BOLA execution date. This provides a grace period for AMP financial planning to dial down any ongoing client fees following a BOLA transaction. Now that's a reference, isn't it, to the 90-day rule?
I'm not sure. I have inquired about that document. I am uncertain as to why that 3-month grace period is there.
Is it still there?
No, as in reflected in that document. So I don't understand the purpose of that reference. So the linkage of the 3-month grace period to the FDSs.
Sorry, you don't understand why the FDSs are linked to the 3-month grace period.
Yes.
But the audit report explains why that is, which is that by implication, so that you don't need to issue another FDS within the first 3 months of the client register hitting the BOLA pool, that the selling advisor will have given an FDS that extends out. That's what it's saying, isn't it?
I'm not entirely certain.
Well, do you agree that this is plainly a reference to the continued existence of the 90-day grace period? Or
I'm not
except-
sure that it is.
What else could it mean?
I'm uncertain. I have inquired as to whether or not there is any linkage to that 3-month rule with the FDSs.
I'm sorry, what is it that you've inquired into?
The linkage between the 3-month grace period and the issuance of the FDS. So the question is whether or not that was to enable fees to remain on or not.
Well, let's break it down. It refers to a period of up to 3 months post the intended BOLA execution date. You see that?
Yes.
And then it says, this provides a grace period for AMP financial planning to dial down any ongoing client fees following a BOLA transaction.
Yes.
It's explicitly referring to the fact that fees might not be dialed down for up to 3 months after a client register hits the BOLA pool, isn't it?
It could mean that, yes.
What else could it mean?
As it was explained to me when I asked the question, it could be to just set processes up, but it certainly could mean to dial those for that to be a grace period. Yes, I agree.
Who did you, when you say when it was explained to you, who explained it to you?
Just in terms of asking questions in respect of this with our legal team.
Your legal team explained it to you?
Yes.
That it
Well-
might... Yes, go on.
So I agree that it could well be what you're suggesting it is, but I'm not entirely certain.
And you're aware of who the internal audit report was distributed to?
Yes, I am.
And one of those people is Mr. Caprioli, your predecessor.
Yes.
Another of those people is Mr. Mellor, the Chief Executive Officer.
Yes.
And have you asked Mr. Caprioli what he made of this statement in the audit report?
No.
Have you asked Mr. Mellor what he made of this statement in the audit report?
No.
Why not?
I don't believe we've discussed it.
Commissioner, what time did you propose to sit to?
Just teasing me, isn't it, Mr Hodge? I had intended to go through till 4:15, but what do you want to do?
I'm happy to
Let's-
keep going.
I think, well, how are you going for time is the real question.
We'll be back tomorrow in any event, there's no doubt about that.
Well, let's go on for another 10 minutes at least.
Thank you. Now, I think by my count, we just finished with the 6th false or misleading statement that AMP made to ASIC. Can we now bring up the document which is AMP.0001.0049.0708? We've skipped over one, Mr. Regan, out of order. This is a letter of the 17th of August 2015 from AMP to ASIC.
Yes.
And just give me one moment. And can we bring up page 0716? And you see, or if we blow up the the last lengthy paragraph on that page, beginning the breach dated 27 May 2015. And you see the sentence, requests were made to product issuers by the licensees to have service fees turned off. Through errors on the part of both the licensee and the product issuers, fees continued to be deducted after the servicing arrangement had come to an end. That was also a misleading statement, wasn't it,
Yes.
Mr. Regan? Because it excluded references to the intentional decisions by AMP
That's
to keep
correct.
the fees on. Thank you. I tender that, Commissioner.
That will be Exhibit 2.21, letter AMP to ASIC 17 August 2015, AMP 000100490708.
And then can we bring up AMP.0001.0017.3286? Now, this is a set of PowerPoint slides that was prepared for the purposes of a meeting with ASIC.
Yes.
And if we go to page 6 of that document, you'll see this is a template letter that ASIC was informed had been sent to customers.
Yes.
And about halfway down the page, it says, when we set up your financial products, we negotiated a plan of service fee in return for certain additional financial services to be provided to you. As AMP will no longer be able to provide you with all those additional services, the plan of service fee will be removed.
Yes.
Now, had those letters been sent to all clients, then that would have been a misleading statement to the clients. Do you agree?
Yes.
But in fact, even though ASIC was told that these letters had been sent to the clients, in fact, they weren't sent to the clients, or they weren't sent to all clients.
I understand that to be the case.
All right. So the further misrepresentation made by these slides was that AMP had been informing clients that it would turn off the fees. We go back to page 3, which is .3288. And you see the opening sentence says, various AMP entities self-reported the discovery of an administrative error where ongoing services were not turned off. And then under the heading background, the third point, when licensees purchase register rights, the normal process is for the ongoing service agreements to be terminated and the ongoing service fees to be turned off. Do you agree that that statement was misleading?
Yes.
Thank you. I tend to that, Commissioner.
Exhibit 2.22 PowerPoint. Is this the PowerPoint presentation?
Yes,
Yeah,
Commissioner.
PowerPoint presentation, AMP to ASIC, 17 September 2015, ongoing service fee remediation, AMP 000100173286.
And then can we bring up AMP.1000.0001.4754? And this is a letter from AMP to ASIC in response to a notice of direction under section 412 capital C. You see that, Mr.
Yes.
Regan? And if we go to page 3 of the document and we blow up the top half of the page, you see the administrative processes that failed are, and there's then various explanations about the failure of administrative processes.
Yes.
And again, you agree that was misleading,
Yes.
and that, by my count, is the 10th false or misleading statement that was made to ASIC. Now, it also says that the agreements were terminated and the clients were not entitled to receive fees.
Where are you reading from, Mr. Hodge?
I think it needs to go,
I'd have to come out from the...
yes. I'll come back to that.
Yes.
Oh, I'm sorry, it's actually at the top. You see, therefore, the responses below relate only to the 6,963 formally advised customers of AMPFP whose service arrangement had been terminated before they were affected by the reported breach.
I'm lost.
I'm sorry, it's page 4758. Beg your pardon, it's page 5. If we go to page 5, got 4758.
Second paragraph.
I think I'm being told I should have stopped at 4 o'clock by this course of events, Mr. Hodge.
Well, Commissioner,
Let's get to the end of it and then we'll stop.
that's right, I'll tender that document, Commissioner, and
Well,
I'll
can we just
return to it.
find where this passage is? It's page 5, do you say?
Yes, do you see the statement, Mr. Regan? Therefore, the responses below relate only to the 6,963 formally advised customers of AMPFP whose service arrangement had been terminated before they were affected by the reported breach. And that was incorrect, wasn't it? Because in fact, in many cases, their service arrangement hadn't been terminated.
Sorry, Mr. Hodge, I'm just not quite understanding it.
That's right, I'll tender the document, Commissioner.
Perhaps come back to it in the morning if we need to. Letter AMP to ASIC dated.
It doesn't have a date on the document, Commissioner.
Letter AMP to ASIC
It's
AMP 1000 0001 4754 will be Exhibit 2.23,
Thank you, Commissioner.
and we'll resume at 9:45 tomorrow.
Thank you.